Good morning. This is Doug LaLone, partner with Fishman Stewart in Troy, Michigan. We are broadcasting to you today a live webinar called Crisis Strategy Tips for Intellectual Property, Triaging Cash Flow. This is the second of two of our webinars this week on the same topic of managing cash flow, yet while trying to protect your innovations. Thank you for joining us here today. This web broadcast is being broadcast around the nation. And we appreciate our web panelists here today. We have three attorneys from our office, Melissa Atherton, Paul Ratzmann, and Michael Fluhler, all working from their homes today, as is the rest of our organization. This is week 3 for Fishman Stewart, working remotely from our homes. I'm sitting here in my basement, as you can see. This is my new office and will be for some time in the future. We hope that you are all safe and your organizations are running well as could be expected. A couple housekeeping items here today. This is a webinar. You will have some opportunities today to ask questions. If you look at the bottom of your toolbar there for Zoom, you'll see a tab called Q&A, as well as another tab called Chat. You'll be able today to post questions to our panelists. We'll do the best we can to answer your questions. At the end of this webinar, we'll be sending out a follow-up email with a link to the recording, so on and so forth. Quickly, a little bit about Fishman Stewart. As I mentioned, we're an intellectual property firm located in Troy, Michigan. We help clients from startups to venture capital to large corporations. We like to help middle market segment companies throughout America. That includes companies with 10 million revenue to up through 1 billion in revenue. That's an area that we like to help. And we focus on intellectual property, and that's all we do. So we help with IP procurement, and Paul and Melissa will be talking about IP procurement issues here today. We work on intellectual property litigation, both plaintiff and defense, as well as strategic IP strategy services, and that's what Michael Fluhler is going to be talking to us about today, providing us some good business tips on how to manage your cash during this time of crisis, yet still trying to protect your innovations. So to get started, I'm going to launch a quick poll. We're going to have 2 polls today, and poll number 1 here we're going to launch is asking some specific questions about your organization, and let me know if you see that. We have roughly 20 seconds, so please post your answers to these 3 questions if you would, and we'll do our best here today to try to roll out the answers. I'm not sure if our panelists can see those questions or not. Can they see them? No, it's just to our attendees. All right. And this will be up in just a few seconds. And then what we will do is get right into our panel. While that's being conducted, I'm going to quickly introduce. Okay, so I have, for some reason, the poll did not launch. So we're going to end that one. I apologize. We're going to transition right into introducing our panelists. Welcome to live webinars. Things always don't work the way, you know. We're going to start with Melissa, ladies first today. Melissa has worked with Fishman Stewart since 2001. First, she was a legal intern, and then she worked as an associate, and now Melissa is a partner of the firm. Melissa helps clients develop their copyright and domestic and foreign trademark portfolio and implement same in an efficient, cost-effective manner. Melissa, welcome to the webinar today.
Thanks, Doug.
You're welcome. Paul, calling in here from Wisconsin. Paul is a partner with the firm, has been with the firm for over 7 years now. He is a patent attorney practicing in various fields, including biotech, mechanical, electrical, mechanical arts. Paul, thank you for joining us today.
Yep, thank you.
And Michael is a partner with the firm. He's been with us for about 6 years now. He practices in various fields, prosecuting applications in multiple technologies, as well as works with IP litigation matters on various mechanical and computer technologies. And he has extensive experience in IP licensing matters. So let's start with Melissa. Just a little quick roundabout question. We're all working from home. Just check in for a real quick a minute and let us know how are you all doing from home.
I'm doing good. You know, my whole family is healthy, so that's great. But we are all here at home. So when you hear my kids on this call, I guess please forgive me for that.
That's not a problem. Paul, you're in Wisconsin calling in. How's everything going in Wisconsin? I hear you had an election today.
Yeah, we had the election. I won't go there, but the biggest thing for me is moving into my home office and spending all my time here and working in my basement. So getting that heater going in this cold basement has been my biggest challenge here. But other than that, it's been working just great. We have full functionality here in our home offices.
Great. That's good. I'm glad to hear that. Michael, you're up in Oxford, Michigan. Is that right? How are things up there?
It's looks like it's going to be a nice day, a little overcast, but enjoying it up here, all settled in, and it's actually been quite a busy time. So, despite the circumstances, things are good.
Good. All right. I'm glad you're all well, and we hope our viewers are well as well today. Let's transition right into the heart of the reason why we're here today, and that is to try to help provide some information to innovators in our ecosystem. In particular, in this time of crisis, we want to talk about specifically on the intellectual property front, what can be done to manage cash flow, which is very critical. We have clients that are laying off employees, but yet some clients are still innovating. So my first question really is from the patent office perspective. Melissa, we'll start with you. What is the patent office doing? How have they responded to the COVID-19 crisis?
Well, from a trademark perspective here in the US, the trademark office has offered a 30-day extension for some deadlines, provided that the delay in either payment or filing is a result of some sort of impact of COVID-19. Paul will talk a little bit more about the intricacies, but the bottom line is if you or your business are suffering, somebody gets sick, you're having cash flow issues, at this point there is some relief for you. In terms of relief from other trademark offices around the world, there have been offices that have extended deadlines beyond 30 days. And so if you have questions, you know, there is some help available here in the US and in other jurisdictions.
And just to follow up on that, Melissa, what kind of extensions are we talking about? Things like filing statements of use,
Yep.
Responding to office actions, does that fall within this category?
Yep, so most of your standard deadlines are included. It does not include most deadlines before the Trademark Trial and Appeal Board, although extensions of time to oppose and actually notice of opposition, those deadlines to apply. But if you haven't can be extended by 30 days, but motions before the TTAB and other deadlines cannot be.
Okay, good. Thanks for that clarification.
Well, actually, you basically request extensions through your normal protocol. There's not this 30-day, I guess, presumed extension.
Okay, good. Thank you for that clarification. Paul, let's switch over on the patent side of the patent office. How has the patent office responded to the COVID-19 crisis?
Well, the patent office came out with 3 directives in recent weeks. The first one was on March 16th, and that was a very quick response to what's going on in the world, where if you have a patent or a trademark that has become inadvertently abandoned, it's a result of the COVID-19 outbreak, then they have provided certain relief, such as in petitions to revive the fees for doing that. And so that's the first thing that the patent office immediately did. But then on March 31st, they came out with 2 further and more detailed directives that were kind of an outgrowth of the CARES Act, where one was directed toward the trademark side of things, and that's what Melissa was just alluding to as well. The second one was for patents. So they came out with 2 separate ones, and they have a much broader definition of how your business is impacted by what's going on. And so if your business has been impacted due to cash flow or due to shuttering the door, whatever, you don't have to be personally impacted by an infection or something like that. And with that, if you qualify under these kind of broad directives, then you get certain relief in extensions. So in the patent side of thing, there have been about a dozen dates that are available for extension, and they fall between March 27th and April 30th. And so if you have a due date that comes due during this period here, you can get a no-fee 30-day extension from that to kind of take us back into a period beyond that when you can then pick up once things start to normalize after this period here that we're in right now.
To follow up on that, Paul, can you give us an example of a couple of types of the tasks that falls within this patent category where these extensions are available to innovators?
Yeah, that's right. So one of them is, as an example, if you have an office notification that's due, and you're a small entity or a micro entity. So that's what the patent office defines as, instead of a large entity like a corporate, if you're a small or micro entity and you're during a certain pre-exam period of time, you can get an extension there. So it's particular to small and micro entities. Another example is if any applicant has a pending application in an office action that falls due within this period of time here, then if that due date falls, you can just get an extension of time and you don't have to worry about paying a fee later down the line or something like that. Another one, as an example, is if there's an issue fee due, the issue fees are now if you have an issue fee that falls in this period, you can go out 30 days beyond that and just take advantage of that opportunity. Those are just a couple of the dozen or so that are in there. Right.
And just to clarify, both on the trademark side and the patent side, does an applicant have to do anything in advance to get this extension?
They do not. So what you can do is, after the fact, there's some discussion in these directives, but if you just make the representation that your business was impacted, et cetera, there's some language in there, then you can, after the fact, come in and take advantage of the extension opportunity.
Okay, good. Thank you for clarifying that, Paul. Michael, let's transition to you. From an in-house perspective, you were in-house at a medical device company for many years. You oversaw some very large patent portfolios, and you manage a lot of spend on the patent front. In this situation where maybe an innovator can't afford the patent process or the trademark process because of a cash crunch, what are some of the IP techniques that a company can use for optimizing their competitive advantage to help them overcome the current circumstances?
Yeah, thanks. A lot of these are based on internal business policies. So it's the protocols you have in place to identify and capture innovation and other kind of aspects that lead to a competitive advantage. And a typical first step in that is inventorying what you have. What are the components of, what are aspects of what innovation or patents do you have, what copyrightable items do you have, and then what trade secrets may you have. And then as part of that, documenting the innovation, getting the invention disclosure practices. So as part of that R&D and those services and all those things are ramping up, get the disclosures from the inventors and the key business people that are involved with that, and then make some determinations. So maybe filing patents is on a route, or trade secrets, or you can evaluate the different copyright aspects of it. But a key thing in these kind of times is a trade secret policy. So there's no filing costs, no exterior costs for government agencies, anything like that. It comes down to what internal mechanisms you have in place to maintain secrecy. And so to briefly touch on that, it's generally trade secrets are, for one, they're secret. It's right in the name. They have independent economic value from it being secret. So if there were to be a disclosure, there would be an economic impact. And then the third one is that you've taken reasonable measures to maintain the secrecy. And so those are all internal protocol type items. So do you have a policy in place that when a certain piece of innovation comes out, Where is that stored? How is that information transmitted? Are you keeping track of the chain of custody of that information? All those kind of, do you have access controls in place? All those weigh into whether you're taking reasonable measures to maintain the secrecy. As some additional touch points on this is typically the short list of information. This is the top things that are business critical. These are the things that should be safeguarded, like the recipe for Coca-Cola. These are, if that came out, those are detrimental business items. It's not going to help to stamp trade secret on every piece of information, even stuff that's publicly available. It's definitely a balancing of resources to maintain secrecy and what's really crucial to the company.
Oh, thank you. That's a very good point. So it sounds like trade secrets and making sure you have a trade secret policy in place could and is actual an effective policy if you can't deploy filing patents or filing trademarks. Is that correct?
Yeah, correct. As one last consideration, trade secret protection, like it has to be secret. So there's a couple of considerations like reverse engineering. If you can look at the object or whatever it may be, and somebody looking at it could figure out how it was made, how it was used, those things that are reverse engineerable are not trade secrets. So it's definitely a balancing, but yeah, it's an effective method of protection.
Okay, all right. Let's transition to Melissa right now and talk about some ways from a trademark perspective that a company can minimize or delay trademark costs that may be associated with maintaining a trademark portfolio. Melissa, what are the options out there for people to try to save costs on the trademark side?
Thanks, Doug. That's like the most popular question of the day, I feel like.
Okay.
So there's 3 big tips that I have for you today. The first is, like we talked about, taking advantage of extensions if they're available in the US and in many countries around the world. If you're, for example, maintaining a trademark registration, there are grace periods available. They're often 6 months, or there's usually grace periods available. And they're usually about 6 months. There's typically a small fee associated with the grace period, a few $100s, but that may be money well spent under the circumstances to give you another 6 months to see how this works out and to get us through this storm. The second thing you can do is review your portfolio and prioritize your filings. If you're considering phasing out a brand next year, maybe you choose not to maintain registrations for those brands this year because you already know it's being phased out. So that's one way to save money. Another way is to potentially narrow the scope of your protection. So as an example, if you are a restaurant and you have a registration for, let's say, restaurant services, but maybe because you sell t-shirts and stuff like that for your restaurant, you also protect those goods, which when you're maintaining a trademark registration means more money. So maybe you choose to only protect restaurant services because they're your core services now, and remove t-shirts because it's not worth the investment at this point. And so those are kind of 3 easy ways to either save money or kick the can down the road until this crisis is over.
In the last week or two, Melissa, which of those 3 areas have you seen clients stepping up and asking you for help?
I think the grace periods is probably the most popular, but certainly we've counseled on all 3 topics.
Okay, good, excellent. Thank you for that information. Paul, Melissa talked about some cost-saving measures on the trademark side. Let's switch to the patent side. What are the low-cost options to reduce costs yet continue to try to protect a company's innovations? Because think about it, companies are still innovating. Perhaps in view of this crisis, they're innovating even more than ever because they're stepping up and coming up with new products that need to be developed, and they're launching those products. So what are the low-cost options they may have to try to save cash during this crisis?
Well, to save cash on your existing portfolio, if you've got a patent patent applications pending either in the US or foreign, your first action is to, I mean, let's face it, you may have much higher priorities than worrying about prosecuting your patent applications. And so these directives that came out from the patent office allow you to just worry about what's on your plate now about your own business and plan to take these extensions. Those extensions are available. Like we said earlier, you don't have to take any immediate action. If you have due dates coming during this period from March 27th to April 30th, you can just press hold and let that date push into next month and just immediately stop the cash flow on whatever expenses you may have to do to maintain and continue prosecution of your patent application. And the other thing too is the same thing may be available, not under these directives, but oftentimes overseas clients or applicants have an ability to just obtain say a 2-month extension that has no fee. Now that might be just a normal course of business. So now you can inquire about that and just take advantage of that now and just push that out, worry about what's going on now that's much more near and dear to your business, and worry about these other actions that you have to take with the patent office a month or so from now.
Right. Okay. I understand there's a concept out there with smaller inventors where they can pay a fee called a micro entity. And I understand there's micro entity, small entity, and large entity. So not to get too deep in the weeds, but is it possible for perhaps an innovator that can file a micro entity fee? And if so, what does that mean to them? And how does that save them some money?
Well, if you're, the patent office has this definition between a small, medium, or small entity, large entity, and a micro entity. And a micro entity is defined as maybe a sole inventor that's only had 1 or 2 patents. There's certain definitions to qualify, and you have to have certain income requirements. But if you qualify as a micro entity, you can engage with the patent office at fees that are a quarter of what large entities like corporate entities pay. The corporate entities pay what's called a large entity fee for all the activities that they do. Small entities get a break of 50%, and the micro entities get a 75% break on that.
Okay. I have a question here from the audience. And the question pertains to, can they file a patent application and not pay the fees now?
That is an option. Yep, that is an option that can be done. And so if we go into it, there's basically two types of applications that you might consider. A non-provisional, which is your standard patent application that many people are familiar with. It's a utility patent application. You have a provisional patent application, which is something that can be done based on informal documents, and it's something that can be, if you're innovating, you're making technical presentations, you've got design documents, and you continue to move on, and you're saying, hey, we're innovating, but we don't have the money, we don't want to take the expense now. You can file, and the provisional, as distinct from the non-provisional, gives you the opportunity to file your paper now, get what's called patent pending, and that's what a lot of people are familiar with, getting that term there. And you can even defer payment and pay your fees down the line, establishing your priority date. Now that may not come without penalty. You'll get a surcharge later for non-payment of the fee. But then if you're a small entity or a micro entity, you can just do this now and not make the payment, and then get a notice to pay the fees later. So it's something that you can do quickly, easily. Provisional patent application is a quick thing that can be done with no cost associated with right now if you've got the documents, and you can work with someone to get that filed.
Good, thanks for that clarification. Those sounds like some good cost-saving tips that innovators can be deploying now, yet still trying to protect their innovations. Michael, let's transition to what some businesses can be doing. We've been focusing more on the patent and trademark side, but as we all can appreciate, unfortunately, employees may be let go during this process. They could be key employees that are innovating, both before the crisis started or even during the crisis, but because of cash flow reasons, the company just can't maintain keeping the employees all present. We're hearing examples about that every day taking place. So Michael, what can companies do to protect their innovations when key employees, unfortunately, are being let go because of the COVID-19 crisis?
Yeah, thanks, Doug. In terms of, again, it comes back to a lot of the internal policies. So three major considerations come up in terms of the scope of employment. Is a lot of the innovation that's coming out of the relevant to the employee? Is it related to the company, to key practices of the company, or is it more tangential to the company? So in terms of getting a handle on what IP this employee may have. Secondly is non-compete considerations. Does the employment agreement have a non-compete provision? Is the employee they giving a severance package that may be an opportunity to supplement some of the non-compete considerations? And when all that is going on, even if there's a non-compete provision in the agreement, you still have to consider whether the duration, the timing, the geographical area of the non-compete, and also the scope of employment line of business is all reasonable in light of the business interests. You may have a very national business and throughout the United States, and the employees' activities have been prolific throughout the United States, and maybe there's justification for a broader geographical scope. But it's all a balancing of individual roles, line of business, and it has to be catered to what is reasonable to be in basically restricted on the employee in line to the business interest. And the last one is ownership. So who owns the IP? Do the employment agreements specify that the company owns IP? Again, what is the scope of what the company owns? If the employee goes home and works on something in their garage every night that has nothing to do with the business, it's probably a little bit outside reasonable to expect the company to own that. However, if the company's working on a company laptop, saving things to the company drive, this is core to the role, I would say the company should own it. And so do you have an agreement? Do you have a policy kind of memorializing what behavior of employees? And then the last thing is as you're building that innovation, all that, are you having employees sign timely assignment documents to actually transfer title to the company? So all those are kind of, there's no, if it's layoff time is today, that your options are, there's some options, but it's better to have the approach of let's get the appropriate policies in place so we're prepared for a month from now, a couple weeks from now, those kind of things.
Right. So I just want to follow up in our last question. You were talking a little bit about trade secrets, and now you were just talking about getting policies in place in the event an employee leaves. Hopefully the policies will help the company in that situation. What if there's not a policy in place? What if it's a small company? What if it's a startup with a handful of employees or something like that? Or maybe it's a medium-sized company and they just never got their IP policies in place consistent with their employment documents. From a trade secret perspective, if an employee leaves, who owns the trade secret at that point in time? What's your understanding or thoughts on that?
So the trade secrets, it's again, it's typically going to be, it's based on agreements. Various states have different statutes on ownership of innovation and stuff, but you know, it's I would say more likely than not, if it's related to the company owns it. Now, the practices to perfect a lot of that and how that trade secret is going to be able to maintain are an entirely different story. So as a quick example, if today you have to make layoffs, it's probably in your best interest to check the innovation that's key to your company. And before you do anything, make sure you have the appropriate documents in place so that's secured. And as you're moving towards those workforce adjustments, making sure that all the people who are being adjusted, whether hired or laid off, know the policies. And so they actually have knowledge of what they should do, what they should not disclose, and those trade secrets need to stay at the company.
Okay, thank you. I appreciate that clarification, Michael. I'm going to try this one more time. I'm going to try to relaunch a second poll. If you get it, let me know. If you don't get it, let me know. We'll see how if this works. We're kind of doing this on the fly here, so bear with us.
Right.
Do you see it?
I see it.
Okay, Melissa sees it. So hopefully our guest sees it. It's 3 questions, kind of follow-up questions. And then we'll transition to a kind of our final comments by our panelists here today. This webinar is meant to run for approximately 30 minutes. We're coming up on the 30-minute mark. We have about 100% of the questions are now answered for the first question, 50% coming in now with the second question, and then about 70% now for the third one. So we're almost complete. Give me a few more seconds here. It's kind of fun learning this technology here on the fly. We appreciate your cooperation. Just a little tidbit while we're just wrapping up here. We're almost at 100% on the poll here. We will be having more of these webinars over the next several weeks. If you have interest in various topics, please send a note back to us on topics that you would like to talk about. We're going to do a short recap here, but I just want to take the next few minutes here to give our audience an opportunity to weigh in on topics. Or if they have questions, please send in a question through our different channels here, and then we will take those questions into consideration. So I'm going to share the results here. We had 100% people found the conversation helpful, informative. We had 54% of people interested in learning more about protecting their innovations, brands, and creative works. And then 77 people indicated that webinars is the best way to be informed during this time of crisis. 54% people said they want to read white papers. And then 23% indicated that social media is a channel that they would like to use going forward to learn more about what we're talking about here today. So we're just going to go around quickly and wrap up within the next 5 minutes here. I'm going to start with Melissa to please share with us some parting thoughts and tips on managing cash during this crisis, and what are your suggestions?
Sure. So there are absolutely things that can be done to minimize spend and delay spend, both with respect to enforcing or with maintaining your trademark portfolio, with enforcing it, as well as protecting new brands worldwide. There's definitely things that can be done. You know, we're working with our clients right now to do that. And to the extent that we can provide help to you, we'd be happy to do that.
Okay, good. Thank you, Melissa. And it sounds like your crew is waking up from their nap.
Yep, it's that time.
Yes, Melissa has 2 households that she's trying to manage. Her sister's in town with her family. So Melissa, thank you for hanging in there today and being patient with us. And thank you for participating. We appreciate that. Paul, any final thoughts you have with sharing with our individuals here today?
Yeah, the 3 main points I think I would like to leave the audience with is, the first one is that these directives came out. The directives are available for business impacts that are that are related to the COVID-19, and they're available now, and we'll be watching them to see if there are extensions granted or anything like that. The second one is you can immediately stem the cash flow by taking advantage of these directives and paying attention, and just worry about your core business and things like that, and don't sweat the due dates that are immediately coming due, assuming they qualify for these directives. And the third thing is, as you continue to innovate, you have quick tools available. So instead of going forward with the full non-provisional utility patent application that you may normally pursue, you can pursue a provisional very quickly. You can defer the cost till later, and even not file your fees now. You have no cash outflow, and you can still protect your ideas.
Yep. Those are great points, Paul. We appreciate those thoughts from you. And Michael, any final thoughts on what companies can be doing from the in-house counsel business perspective to try to protect their innovations and manage cash through this crisis?
I think so. This is the key time in terms of any kind of turn. You know, history has proven that anytime there's turns in the market, changes, things like this, you'll see a influx of people surging into solutions in that space. And so it's kind of a takeaway, at least from my perspective, is look at some of your internal R&D teams, what you have existing, and how can you organize your existing IP assets, your R&D workforce, and align it with a solution for the company, and how can you leverage the current circumstances to advance the business.
Yeah, those are great business tips, Michael. We appreciate it. Well, this is a wrap up now of our webinar. Our second this week. We'll be rolling these out in the next several weeks. Please stay tuned. I want to thank Melissa, Paul, and Michael from all parts of the country for weighing in today from your homes and your home offices. We appreciate your time and for preparing this and putting us on today. We hope our attendees all learned something new here today. This is brought to you as a hope to provide some information, current relevant information to our entrepreneurial ecosystem. So we hope we've accomplished that with you. If you would like more information about this webinar or future webinars, if you go to fishstewip.com, you will see this webinar will be reposted to be rebroadcasted. And there will be also the updates that Melissa and Paul talked about, those white papers regarding how to save money and view what the Patent Office is doing. Those papers are posted on our website as well. And also, if you would like to reach out to any of our panelists, you will find their bios and their LinkedIn connections on the initial email blast that was sent out to you all this past week. And you feel free to reach out to them directly and ask any questions. They'll be glad to help out. So thank you all. Again, this is Doug LaLone from Fishman Stewart. We thank you for participating here today. This concludes our webinar. Please stay safe. Please abide by the CDC guidelines and keep your distance. We wish you, your business, and your family the best of health. Good day. Thank you.